talking about the Beru Bari case of 1960, and that was the time when India was in the process of forming and working upon the constitution. ठीक है, नया नया कॉन्स्टिट्यूशन बना था और काफी प्रॉब्लम्स आ रही थी. तो दिस बेरुबारी केस has two-three questions which came in our minds for the first time. पहली बात कि preamble का significance क्या है, क्या use है preamble का, what is the applicability, is preamble really working, is preamble a need, a prime need. Then the second question was, is preamble a part of the constitution, can that preamble be amended? So these questions gave rise, and then there was this case. Now, Beru Bari case began, and the time phase was India and Pakistan were in the process of partition. In 1947, the states were divided. India came out as one state and Pakistan the other. Now, during that time, एक प्लेस थी जिसका नाम था थाना बोडा, BODA, बोडा. And it was while the partition was being done and the states and territories were divided, this place, Thana Boda, वो गलती से incorporate करना भूल गए. ठीक है? And who was incorporating all these things? One Britisher called Sir Cyril Radcliffe. I repeat, Sir Cyril Radcliffe, he was the chairman of the Borders Commission. उनको ये काम दिया गया था. He was vested with the responsibility of giving the proper boundaries, the border between Pakistan and India. And while he was drawing the borders, he calculated and did everything very wisely. The distribution was done on the basis of population having the Muslim majority. It was given to Pakistan. Then the population with Hindu majority, that place was given to India. So it was basically working on the principle of majoritism. So जो Sir Radcliffe थे, he was working on the principle of majoritism कि जहाँ ज्यादा जो particular religion के लोग हैं उस basis पे divide हो रहा था India और Pakistan. Everything was going well, but what happened was he forgot to draw and incorporate this small little place. Beru Bari is a small group of villages, and it is in Jalpaiguri district of today, जहाँ पर West Bengal है, वहीं पर है वो. मतलब अब वो West Bengal का part है. So it was in that place, Beru Bari. It fell in the under two thanas of Jalpaiguri and Boda. दो थानों के बीच में पड़ता था वो, Jalpaiguri and Boda. And while Radcliffe was drawing these territories, he forgot about this particular place, Beru Bari. So he drew all the boundaries as a chairperson. He did the responsibilities, and the things were vested with him. The people had vested the responsibility of giving the boundaries, the border between East and West Bengal. Bengal was considered as Pakistan's territory. It was the East Bengal, which was another name for Pakistan. Okay. And the West Bengal is a part of India even today. So few days later, in 1948, Pakistan, he started claiming for this place, Beru Bari. So again, a proper tribunal बैठाया गया, and that tribunal was known as Lord Badge Tribunal. और उसमें जो setup किया गया, it was to address all kinds of boundary disputes. It was in 1948 and 49 when Lord Badge Tribunal sat down to sort out all the disputes. And it was here that when they sat down for disputes solving, then Pakistan did not open its mouth. It did not talk about the Beru Bari case, कि इस particular territory का division होना है या ये किसका part है. Then Beru Bari was not even mentioned. In fact, until 1952, Pakistan never raised a question of Beru Bari, and it was generally concluded that Beru Bari was the integral part of Indian Union. क्योंकि पाकिस्तान को कोई ऑब्जेक्शन नहीं था, तो यही माना गया, यही डिसाइड ही हुआ कि it would be part of Indian Union. So Beru Bari had more of Hindu population also. So this made it all the more clear कि it will be incorporated in India only. Then the CM of Bengal at that time was Bidhan Chandra Roy, BC Roy. ठीक है, I repeat again, Bidhan Chandra Roy. He was the chief minister of Bengal, West Bengal at that time. And at that very same time, उसी समय पर जब ये बेरू बारी का केस हो रहा था, उसी समय पर नेहरू जी and Noon, these were the two representatives from India and Pakistan who decided an agreement. उन लोगों ने आपस में एक agreement sign किया 1958 में. It is called Nehru and Noon Agreement. ठीक है, NOON, Noon Agreement. ठीक है, नेहरू एंड नून अग्रीमेंट. अब इसमें इन्होंने क्या किया, दोनों ने डिसाइड किया टू एक्सचेंज द टेरिटरीज कि whatever you give me some, I will give you in return the same proportion, and we can exchange the territories. Then second thing what they under this agreement decided was Beru Bari Union of 12 would be divided horizontally, and northern Beru Bari to be given to India and southern Beru Bari to be given to Pakistan, that is East Pakistan, that is present day Bangladesh. ठीक है, तो ये दोनों ने मिल करके बड़ा आपस में खेल खेला कि चलो आपस में टेरिटरीज बांट लेते हैं, एक्सचेंज कर लेते हैं, और बेरू बारी के केस में जो नॉर्दर्न पार्ट ऑफ बेरू बारी है वो इंडिया का होगा, सदर्न जो होगा वो पाकिस्तान का होगा. Now they were going for this agreement, whereas Bidhan Chandra Roy, who was the CM of West Bengal at that time, he opposed this agreement. And he was against this because Beru Bari being the Indian state, I mean, more of Hindu population, he was opposing that. Other than that, there were more than 12,000 villagers, जो कि Hindu थे. They had cut off their fingers and wrote to the then then president of India, that who was the then president of India, Dr. Rajendra Prasad, and they told him that they don't want to be a part of Pakistan. ठीक है, तो हुआ क्या, विधान चंद्र रॉय ने उन विलेजर्स का भी टेकअप किया, एंड ही वाज टोटली इन फेवर कि हाँ भाई यहाँ पे हिंदू पॉपुलेशन है तो हम क्यों दे दें इस एरिया को पाकिस्तान को. So while they wrote, the villagers who wrote with their, they cut off their fingers and from their blood they wrote to the president Rajendra Prasad, and they wrote Amar Rakta Debo, Pran Debo, Beru Bari Debo na. मतलब कि हम अपना रक्त दे देंगे, we'll give our blood, we'll give our life, but we will not give our territory, Beru Bari, to the nation of Pakistan. Now, with this thought, Bidhan Chandra Roy, he approached the president. The letter which was written to him by the villagers plus the chief minister of West Bengal, they approached the president, and Dr. Rajendra Prasad, he had to interfere. उन्होंने बीच बचाव करा. Now he had the power that under Article 143. Article 143 says, क्या कहता है? President has the power to consult the Supreme Court in case of any legal matter which is in interest of public importance. So that means president can interfere because this matter had the public importance in it. So Supreme Court would decide or deny the opinion. So it was in the hands of Supreme Court that whether they should agree to it or they could deny to what president wanted them to listen. So now president had few questions in mind. उन्होंने कुछ क्वेश्चंस के संग सुप्रीम कोर्ट में अर्जी लगाई. फर्स्ट वाज, इज लेजिस्लेटिव एक्शन नेसेसरी फॉर बेरू बारी यूनियन? उन्होंने सबसे पहला क्वेश्चन पूछा कि क्या लेजिस्लेटिव, मतलब लॉ मेकिंग बॉडी का एक्शन लेना जरूरी है बेरू बारी में? Is parliament not to be asked? क्या पार्लियामेंट से नहीं पूछना चाहिए? दैट मीन्स द एंटायर गवर्नेंस इज जस्ट बिकॉज इट इज इन द गवर्निंग हैंड ऑफ अ पर्टिकुलर फ्यू पीपल, तो क्या सिर्फ उन्हीं से पूछना पड़ेगा हमको? पार्लियामेंट का कोई से नहीं है इसमें? दिस वाज हिज फर्स्ट क्वेश्चन. देन सेकंड ही सेड, if asking the parliament is necessary, then article 3 can be passed. उन्होंने कहा कि भाई अगर पार्लियामेंट से पूछना जरूरी है तो फिर ये भी अगर उनसे जरूरी है क्योंकि तभी आर्टिकल 3 एप्लीकेबल हो पाएगा. Then he also said Article 368 would be needed to amend if it is given away by the government without the consent of the parliament. और उन्होंने ये भी कहा कि अगर हमने आर्टिकल 3 के तहत ये दे दिया तो आर्टिकल 368 जो कि कहता है कि गवर्नमेंट की पार्लियामेंट की राय जरूरी है, तो फिर इसमें गवर्नमेंट का हाथ नहीं हो पाएगा. दैट मीन्स ही वाज टोटली आस्किंग दीज क्वेश्चंस क्योंकि आर्टिकल 368 ओनली गेव पावर कि आप अमेंड कर सकते हो कॉन्स्टिट्यूशन को, एंड आर्टिकल 3 वाज टॉकिंग अबाउट द राइट्स. तो उन्होंने कहा कि भाई अगर 368 में आप पार्लियामेंट की ही जरूरत नहीं कर रहे हैं तो यानी कि ये तो कुछ गवर्निंग बॉडीज के हाथ में आप दिए दे रहे हैं. अब इसके ऊपर आर्ग्यूमेंट्स होने शुरू हुए. सो द गवर्नमेंट आल्सो गिव द आर्ग्यूमेंट. उन्होंने कहा कि नो सेशन ऑफ लैंड, सेटलिंग ऑफ बाउंड्री डिस्प्यूट बाय एक्सचेंजिंग द लैंड. उन्होंने कहा हम कोई लैंड अपना दिए नहीं दे रहे हैं, ना कुछ घसीटे ले रहे हैं किसी का. हम खाली बाउंड्री डिस्प्यूट को सॉल्व कर रहे हैं, वो भी एक्सचेंजिंग करके, लैंड को एक्सचेंज कर रहे हैं. जितना हम दे रहे हैं उतना हम पा भी रहे हैं. ये गवर्नमेंट ने आर्ग्यूमेंट्स दिए. देन दे आल्सो सेड कि लेजिस्लेटिव इंटरवेंशन इज नॉट नीडेड, कि उनको नहीं चाहिए था, वो नहीं चाहते थे कि पार्लियामेंट बीच में आए. अब उसके एक्सचेंज में आर्ग्यूमेंट्स दिए गए, जो कोर्ट ने ऑर्डर्स दिए उनके, उसके लिए उन्होंने बोला अकॉर्डिंग टू प्रीएम्बल. अब आया ये टर्म प्रीएम्बल. उन्होंने कहा पार्लियामेंट हैज नो पावर टू ऑल्टर द टेरिटरी ऑफ अ कंट्री, क्योंकि इंडिया का सॉवरेनिटी वर्ड यूज हुआ है उसमें और यूनिटी वर्ड यूज हुआ है उसमें. तो ठीक है, अगर उसको भी देखते हैं तो इंडिया को विभाजित नहीं कर सकते. कहीं पे भी ये नहीं लिखा है कि यू कैन गिव अवे, यू कैन ऐड तो लिखा है प्रीएम्बल में. जो सॉवरेनिटी वर्ड है, it tells you that India stands with the physical boundaries intact and it is one nation. Then it is united, ये सेकंड वर्ड है. तो अगर हम प्रीएम्बल को भी देखते हैं तो कहीं पर भी ये तो नहीं कहा गया है कि आप बाउंड्रीज अपनी दे सकते हो. आप अक्वायर कर सकते हो, बट यू कैन नॉट सीड योर बाउंड्रीज टू अदर्स. So this was the first objection which was given by the court. Then the second thing was raised was Article 1, 3 of Article 1, Section 3 and 3C. Now they talked about it, that acquiring the territories and not ceding any territory. That means again they talked about कि you can acquire the territory, but you cannot give away any particular territory. So on these grounds, the judgment was passed saying that preamble is not the part of the constitution. उसमें sovereignty और unity जो words हमने उसके incorporate किए थे while they were talking about Beru Bari case, the Supreme Court gave the judgment कि though preamble is not a part of the constitution, yet it cannot be quoted for any particular case. ठीक है, आप कोई कोर्ट के केस में प्रियम्बल को कोट नहीं कर सकते हैं. इट इज जस्ट अ समरी ऑफ द होल कॉन्स्टिट्यूशन. देन द जजमेंट वाज आल्सो ऑन द ग्राउंड्स कि आर्टिकल 1(3)(c only talks about acquiring the territories and not ceding any territory. Ceding मतलब कोई टेरिटरी आप दे नहीं सकते हो. Then it talked about, the judgment also talked about Article 368. Under that it said it gives power to amend the constitution. Hence Article 1 can be amended by Parliament. तो उन्होंने कहा कि Article 368 जो है वो सिर्फ अमेंडमेंट का राइट देता है, पार्लियामेंट को अमेंडमेंट का राइट नहीं कह रहा है वो. There is a proper procedure which is to be followed for any kind of amendment. But amendment has to be brought with Article 368, only then land can be ceded to East Pakistan. तो वही मैंने, as I told you, कि पहले तो 368 में ही amendment लाना पड़ेगा, क्योंकि वो strictly कहता है कि it can be only amended through constitutional ways. So finally हुआ क्या इसमें judgment, और इसके बाद जो नेहरू नून agreement थी, that was nullified. It needed, and it was told that it needed parliamentary amendment. ठीक है, it cannot be just by two persons sitting from opposite countries and deciding upon any issue. That is not correct. So it needed parliament's amendment. Okay, then it did not materialize finally. Why? Because in 1971 the war between India and Pakistan broke, and also it was at this time that East Pakistan broke out from the present day Pakistan, and it became a free country, which now we call Bangladesh. Okay? So this is the actual whole story about the Beru Bari case.